morning, the Court of Appeal dismissed the appeal filed by APNU AFC against the decision of Acting Chief Justice, Senior Counsel Roxanne George, which dismissed election petition number 88, filed in the name of Claudette Thorne and Heston Bostwick. With this ruling, the Court of Appeal has affirmed that the order used to facilitate the recount of the ballots at the 2020 elections was lawful, constitutional, and not in breach of the separation of powers doctrine. Attorney General and Minister of Legal Affairs, Senior Counsel Anil Nandlal, has lauded the court's decision.
We essentially argued that the Election Laws Amendment Act by Section 22 expressly authorizes the GCOM to take certain steps in the face of difficulties to resolve those difficulties. Article 162 of the Constitution similarly authorizes GCOM to do that which is necessary to resolve whatever disputes may arise in order to secure a final declaration of election results at any given regional or general elections.
In April 2021, Chief Justice Roxanne George dismissed the election petition which challenged the legality of the 2020 elections. However, the applicants appealed this decision, arguing that the Guyana Elections Commission's reliance on Section 22 of the Elections Laws Amendment Act to implement the National Recount Order is null and void and of no legal effect. They also claimed that GCOM has no power to conduct an elections recount by way of an order.
What GCOM did was to recount the ballots. To count and recount ballots is a function of GCOM and GCOM alone. So GCOM was not acting outside of the four corners of its lawful parameters and jurisdictional functions. And therefore, there was no basis upon which they can impugn the validity, the legality, or the constitutionality of GCOM's action in that regard.